Good morning, everyone, and thank you for joining us today. Today's session, hosted by Counselor Buchanan and Mitchell and our financial advisory subsidiary, MBI, is entitled The ABCs of Estate Planning, A Wiser Way to Live. Today's session will be 1 hour long, and our presenters are Judy Barnhard and Alex Seleznev. Judy is the Senior Vice President at CBM. She is Vice Chair of the firm's financial planning practice and Director of our professional services group. She's also a Senior Advisor with MBI, the firm's financial advisory subsidiary. In addition to holding a CPA, Judy is a Certified Financial Planner and a Certified Divorce Financial Analyst. She provides individual income tax preparation and comprehensive financial planning. Alex is a Senior Advisor and Portfolio Strategist at CBM and MBI. He's a certified financial planner and a chartered financial analyst, and he leads the firm's investment management division. His focus is on comprehensive financial planning and investment management. If you submitted questions during registration, they have been forwarded to our speakers. They will be concentrating on the contents and will be focusing on the questions a little bit later on in the session. However, we do have a chat box open as well. So throughout the next hour, if you do have any questions, please feel free to enter them into the chat box. Please do keep your video and audio turned off during the presentation as a courtesy to our speakers. Today's session is being recorded. The presentation slides will be made available after the session, and we will also follow up with a link to an evaluation form. So with that, welcome once more, and I'm going to turn it over now to Judy and Alex.
Good morning, everyone. Thanks for joining us today for this presentation. I'm going to start with a disclaimer, of course, that our presentation slides are intended only for educational purposes and are not intended to replace independent professional judgment or financial advice. I also want to add to that, we are not attorneys, but we are certified financial planners and CPAs, and we work in preparing trust and estate tax returns. But as always, we certainly encourage you to reach out to estate attorneys for specific legal questions with regarding to estate planning. We have obviously myself and Alex that Joe introduced. We also have two panelists, Gail Halpern and Tom Burton. And when we get to the Ask the Experts panel, Joe is going to introduce them as well. Counselor Buchanan and Mitchell, we've been around 99 years now. We are a mid-size regional public accounting firm located in Bethesda and also Washington, D.C. And MBI, Maine Barnhard Investments, is a subsidiary of Counselor Buchanan and Mitchell, where we provide wealth management services and comprehensive financial planning services. Our topics today, we will be covering these items here. I also just want to say it's a little bit of a new format that we're trying out. We've been doing a lot of webinars for clients and educational seminars. We are going to allocate about 15 to 20 minutes specifically for the Ask the Expert panel section. We've had overwhelming support for this seminar, over 220, I believe, registrants with 5 pages worth of questions, many of which Alex and I are going to be covering when we go through our slides. But we do have questions that Gail and Tom will be answering. We do ask that you hold your questions in the chat box. We will do our best to get through them, but as I say, we have a lot of questions that were sent in advance, so we're looking forward to answering the questions for you. So with that, what is an estate? I'm going to start, of course, you're going to say there's 2 constants in life, right? Everybody knows it's death and taxes. That's just the way it is. It's Halloween time. It's with the pandemic, with 220,000 people that have died this year so far of COVID, I felt it was important that this is a timely subject because there's many people that really, for whatever reason, do not decide that they want to address what their estate might be or how to handle end-of-life decisions. And so we're trying to be proactive and help you through those decisions now. So what is an estate? Estate assets are the assets that are owned by the decedent at the date of their death. They'll include real estate, personal property, not just automobiles, jewelry, furniture, also think artworks, antiques, certainly your bank, brokerage, investment accounts. When I say with no right of survivorship or beneficiary designation, what I'm pointing out here that is, and this is a legal issue, is how accounts are actually titled. There are some common ones, sole proprietor, which is owned 100% by the individual, but there's joint tenancy, there's right of survivorship, there's tenants in common, there's transfer on death and paid on death, which we have questions about that our Ask the Experts are going to answer. So it's very, very important, if there's a takeaway that you have from this seminar, is make sure that you make an inventory of all of your assets. And then next to that inventory, write down, how is it titled? How is it legally titled? And or if you have a beneficiary, who is that beneficiary? Keep in mind also in your state, IRA and 401k retirement accounts. Life insurance can be part of a state if the owner and the beneficiary of the life insurance is one and the same. So, you know, that's your homework, is to go through, make that inventory, check how it's titled, check who your beneficiaries are. It's very, very important that you follow that. So what is estate planning? Estate planning is obviously going to be involving how you're going to preserve, manage, and distribute your assets at death or incapacitation. It smooths the passing of your assets to your loved ones and or charities. It designates who will receive your assets and handle your responsibilities after your death or incapacitation. Maximizes what you leave behind and may minimize taxes. And it's not just for the wealthy, which is really important. A lot of people think, well, you know, I don't have a big sizable estate, I don't need to worry about this. But as we go through these slides, we hope that you'll understand that you really do need to be considering these items. In terms of goals for estate planning, to obtain the beneficial income tax treatment. So currently, under current law, when someone dies and they leave appreciated assets to an heir, that heir gets what's called a step up in basis. So essentially, if you have, say you have an elderly widow maybe who owns a house with low basis, even if they got a step up from one half of their husband's or wife's ownership in the past, and they've taken their $250,000 exclusion, they may still have a taxable asset there. If they sold their real estate during their lifetime, they ended up paying capital gains tax. But instead, if they rented it or lived in it and waited and left it to their heir, the heir would receive that house at the fair market value at the date of death. So that's what's called step up. It can also apply to securities. Again, securities that have a high value with a low tax basis would be inherited as stepped up basis. Non-tax goals, as we said, making sure that the assets are distributed according to what your wishes are. We've had in our that we see everything, but we've seen assets being left to ex-spouses. We've seen them left to dead beneficiaries. So you know, you may have bought something, or you may have listed somebody on your retirement accounts, and you know it's no longer valid for you, and yet you know you haven't taken the time to go back and clean that up. So again, that's part of that inventory. You know, make sure that you are reviewing who the beneficiaries are. It's very, very important so that you don't have any unintended consequences. To name the decision makers to handle financial and medical events. So consider somebody maybe not of your same generation, maybe someone that's younger, someone that is going to be in the same geographical area, particularly for medical power of attorney, which we'll be going over. But somebody that can actually has the skills to handle these very important decisions for you, and that knows you well enough to be able to honor what your wishes are. To name a guardian for your minor children, and of course to support your charities or worthy cause. Assets such as life insurance, annuities, retirement benefits, they pass directly to the beneficiary regardless of what is included in the decedent's will. Similarly, assets held jointly with right to survivorship will pass outright to the surviving owner, again, regardless of what your will says. So I can't stress enough, be sure you look at how your assets are titled and who the beneficiary is on these important assets. Shocking, as you might say, 55% of Americans die without a will. This is called dying intestate, 55%. So what happens? Well, basically, the process is controlled by a probate court. The probate court appoints an administrator to oversee the estate. The administrator compiles any assets of the deceased, pays the liabilities, and distributes the remaining assets to those parties that are deemed as the beneficiaries. The distributions of assets will be governed by state law and not necessarily the wishes of the deceased. I'll give you an example here. In the state of Maryland, and each state is separate in terms of if you die intestate, how your assets will be ultimately distributed. In Maryland, if you have children and no spouse, the children inherit your assets. If you have spouse and children who are minors, the spouse gets 1/2 and the children get 1/2. If you have a spouse and children that are not minors, the spouse gets $15,000 plus 1/2 and the children get 1/2. We actually had this situation with a client. Her husband died unexpectedly. He owned real estate in his own name that he brought into the marriage. And the children ended up receiving 1/2 of the value of those rental properties. So she, it basically, since she was obviously the guardian and mother of the children, she could go through the process of getting the children to quit claim the assets back to her. But it is an extra step that could have been avoided had the individual have a will in place at the time of death. So what is a simple will? It's a basic document that outlines how you want your estate distributed after your death. It designates a personal representative, sometimes referred to as an executor or executrix, and names a guardian for your children. If you're age 50, under age 50, pretty good health, don't expect to owe estate tax at your death, a simple will may be sufficient to you, but we're going to show you some alternatives that we suggest that you consider. In addition, a will is what's called, quote unquote, admitted by a probate court in the county where the decedent resided at his or her death. It does not avoid probate. It is a public document, and this is something to consider. It's a public document once the decedent dies, so other people can see who you decided to leave your assets to. The cost of probate varies by state. It will vary by the size of the estate and the type of assets in the estate. And a very simple will can take 6 months to a year to basically go through the probate process. A pour-over will. A pour-over will is a legal document that ensures your remaining assets will automatically transfer to a previously established trust upon your death. So it works in conjunction with a revocable living trust. And essentially, it's a backup plan. So if you were in the process of retitling your assets to a revocable living trust, but you didn't get all of them, often cars, automobiles would fall under this. If you had a pour-over will, it ensures that those assets basically pour over and are governed by the terms of the trust upon your death. It declares domicile, but again, as we said, domicile for your state really will end up being where it is that you live at the time of your death. Can name decision makers and guardians for minor children. We consider this property or has minor children should consider creating the pour-over will. A living will. I don't know exactly why it's called a living will because it gets confused with a living trust and also the pour-over will and the regular will. But a living will, it really has to do with medical care. It's basically saying, here are my preferences. If I become incapacitated and can no longer speak for myself, it spells out what medical treatments you would or would not want you to have to keep yourself alive, and other medical decisions such as pain management or organ donation. It can also outline religious or philosophical beliefs or preferences. If you think about it, it's really what your intent is for end-of-life decisions. A durable healthcare power of attorney actually gives an assigned person that proxy to make these decisions for you regarding your health care in cases when you are unable to speak for yourself. And you can have both.
All right. Well, thank you, Judy. And again, thank you everyone for joining us today. So a revocable living trust. And, usually I would actually refer to it as revocable trust, again, for the purposes of limiting confusion. So what is it and why you would want to potentially have one? So in terms of the basics, it's a written document that determines how your assets would be handled after your death. Those assets can include your real estate, your valuable possessions, your investment accounts, your bank accounts. And that's actually one of the reasons why you'd want to have a trust, is if you have many different assets and potentially those assets are actually around the nation. Now, as with other living trusts, you actually create this document during your lifetime. And also you can modify the language in the trust at any point in time. The way it works frequently, you as a grantor would act as trustee of your own trust essentially, and then you would name someone to be a co-trustee, or I should say successor trustee, upon your death. Now, what are some of the main benefits of, again, having a revocable trust? To give you kind of like a number one reason for that, well, a trust like that allows you to control your assets from your grave, essentially. That is the main reason why people will want to have it, to control their funds. Privacy is one of the important issues, again, for some people especially. And as Judy mentioned earlier, if you only have a will, well, then essentially everyone would know how exactly your assets are distributed to your beneficiaries. That is not the case with the revocable trust. The assets that you retitle into the trust, that is very important. The assets that you retitle into the trust avoid probate. That is actually one of the most common issues. I see it all the time, is when people spend the money, they spend the time on developing these documents, they can be quite complex, and then they essentially forget to retitle the property. That, of course, reduces the value of doing this. Now, there are also some potential benefits to the ultimate beneficiaries of the trust, and this is really subject to the provisions of the trust. And this is when we start talking about this, I always mention, if you decide to go this route, you absolutely need to work with a qualified and experienced attorney, because those provisions, they can be state specific, they can be very specific to your situation. So this is not a good time to work with a generalist. But here's a good example of what I'm referring to. Let's say we're working with a single parent, okay, and that person has significant assets. And let's say that person has children who are younger, maybe teenagers, maybe in their early 20s. So what would happen to all of those assets if that person suddenly dies? Well, the children would receive those assets outright. There is no trust in place. Will they be able to manage those investments on their own? Perhaps they should be protected essentially from themselves. What if they're creditors at the time? Bad things unfortunately happen to good people. So that's, again, one of the ways to handle that. And the assumption is that you would have a so-called friendly trustee, preferably someone who's younger than you. That is usually our preference. Someone who knows your family, and someone who, again, would be essentially helping your children with those financial decisions. Next slide, please. So durable power of attorney, or durable POA, how we would normally refer to it. So this document essentially names decision makers who would be making those financial decisions for you if you're unable to do so. Now, for the purposes of clarity, I'm referring to the durable version of the POA. There's also a spring-in version that essentially becomes activated if you become, or when I should say, you become incapacitated. With the durable POA, the agent that you designate can actually act on your behalf immediately. Usually, the powers of the agent are quite wide, to use your assets to pay for your everyday expenses, to buy, sell, and maintain your property, to manage your investment accounts, to collect certain benefits. Here's how it works in practice, at least from our perspective. Many of our clients are in their late 70s, early 80s. We even have some who are in their early 90s. And they want their family members, frequently would be their children, to participate in our financial planning and investment discussions. We are perfectly fine with that as long as they give us permission, to share that information. However, if those children ever reach out to us and want to provide any specific instructions, again, sell something, buy something, or make a cash distribution, we absolutely have to have a power of attorney in place before we actually implement those instructions. So that's important. Now, another point, with different financial institutions, at least the ones I know, Schwab, Vanguard, Fidelity, other financial institutions, they have their own forms. So if you want someone to be your power of attorney, you would most likely need to complete their forms. And that is, by the way, one of the reasons why we frequently recommend that you consolidate your accounts. So instead of having 5 or 7, work with 5 or 7 financial institutions, perhaps you should really reduce that to 1 or 2. And then finally, and we have this issue occasionally, I don't want to say it's common, but it happens every so often. If your POA and your trustee are not the same people, again, let me take a step back. The POA is only active in your lifetime. After your death, essentially it becomes deactivated. It's really your trustee or your executor who would be handling those financial decisions on your behalf. So if it's not the same person, that occasionally creates issues. Next slide, please, Judy. So HIPAA authorization stands for the Health Insurance Portability and Accountability Act. Essentially, it allows a person or party to share specific health information with another person or group. So relatively, I would say relatively simple. I'll just give you an example here. If you have a friend, if you have a relative, or perhaps a child who is over the age of majority, who is admitted to a hospital, and you reach out to the hospital and you ask for that, health information about this person, well, they will not provide it to you, or at least they're really not supposed to, unless there's the authorization in place that basically gives the hospital or the hospital administrators permission to share that information with specific people, yourself, perhaps your financial advisor, someone else. You can really designate that. This document is usually part of the standard estate planning package. There are many options, really. And what we frequently recommend, especially for the HIPAA, is that you complete the form, you send it to your email, so that in case you need to provide this information to someone else, you can easily give access to it to someone like a hospital administrator. Next slide, please. All right. So up until this point, we've been talking about different legal documents, and there's really many different options. Now, what we frequently recommend to our clients for the purposes of, essentially organizing themselves, which is what Judy was referring to earlier, is to complete a so-called love letter to your family. This is just how we would refer to it, a different way of saying it, essentially an estate planning checklist. There many different versions of it. Usually there's somewhere between 5 to 10 pages. Our version here is, so everyone can see it, is 8 pages long. And essentially it includes all of your personal and financial information, your passport number, your social security number, your contact information in terms of your advisors, your attorneys, where you keep your accounts, who owes you money, what types of liabilities you have. It's a very detailed document. You don't necessarily have to complete the whole thing, but again, it helps with organizing your thoughts. And also, once you're done with the process, it essentially would help those that would be, assisting you with your finances to really locate, your advisors and your documents. Next slide, please.
Alex, we're going to be making that available with the slides, right? Just so
Correct.
everybody knows, we will be sending that love letter along with the slides to the participants after the session.
That's right. All right, so the SECURE Act, which stands for Setting Every Community Up for Retirement Enhancement. And I could never really memorize that. So the act became effective on January 1st of this year, of 2020. So it changes a variety of different laws that affect your retirement accounts, your required minimum beneficiary designations, a variety of different things. And we actually had multiple in person at the time and webinars in 2020 to cover this subject. What we'll specifically discuss today is how the SECURE Act affects the stretch IRA planning, which is important. All right, so under the SECURE Act, there's no more stretch IRA. So just to take a step back here so everyone understands what that means, under the old rules, a non-spouse beneficiary was able to stretch out the inherited IRA distributions over his or her lifetime. And that is extremely powerful when there is a significant difference in age between, someone who is receiving the funds and essentially someone who dies. A good example of that, someone is, let's say, 40 years old, and that person is inheriting $1 million IRA, and that person is able to stretch out those distributions over his or her lifetime. As you can imagine, it can be quite powerful. And by the way, it doesn't mean that that person must do it. At any point in time, they can take out the entire amount, but they have to at least take some each year based on the actuarial tables. Now, under the new rules that again became effective on January 1st of this year, non-spouse beneficiaries are limited to only 10 years, which means that if you inherit the money this year, you would have to take the funds out over a 10-year period. You can do it all at once. You can do it in approximately equal installments. You can skip some years, depending on your tax circumstances, or you can wait all the way to year 10 and take out, the entire IRA balance. Of course, that's not likely to be a good idea if you have, a very large inherited IRA. Now, there are some exclusions to the rules. Of course, this does not apply to a spouse. So it does not apply to a spouse. Does not apply to minor children up until they reach the age of majority. So if someone is 14 years old and that person receives some funds in an inherited IRA, for the first 4 years, he or she would basically take the distributions over his or her lifetime. And once that person reaches the age of majority, he would have to take it out over a 10-year period. It does not apply to disabled and chronically ill beneficiaries. And also a very important caveat here that really helped a few of our clients actually, a beneficiary who is not more than 10 years younger than you are, the new rules would not apply to this person. Again, someone who is not more than 10 years younger than you. Here's a good example of that. We work with a person, let's say never married or got divorced, doesn't necessarily want his or her children to inherit the money, but has a sibling, let's say a sister who is 5 years younger. So if that sister inherits the money, she would be able to stretch out the distributions over her lifetime. So there is that caveat. Now, to kind of summarize everything for you, why is this important? Why we dedicated so much time to it? Great, I think it's a good example of this. One of our clients, she's now in her early 80s. Her assets, her financial assets are split roughly equally between her brokerage accounts, her taxable accounts, and her IRA money. Prior to the SECURE Act, the idea was that her 4 children, they're in their 40s at this point, they would receive her IRA funds, equally split, and then of course they would be stretching those distributions over their lifetime. That made sense from so many different perspectives, also from the perspective of the beneficiaries, because 3 out of 4 are actually in the highest tax bracket. So it's very beneficial for them to stretch over their lifetime. And then, of course, the charities would receive the taxable accounts. So when the act passed, we had this conversation. We included the attorney, someone who understands this well, needs to be included in a conversation like that. We entirely modified her plans. Essentially, it's the opposite at this point. Now, her 4 children are going to receive her taxable funds because there's also a step up in basis, which is what Judy was referring to earlier today. And then the charities would receive her IRA funds. From the perspective of charities, of course, they do not really care what types of funds they receive because they would not be paying any taxes. So it took us some time, again, to revisit all of this. But again, it makes a very big difference in how you address it. So if you find yourself in a situation when you have a large IRA or any other tax deferred account and you expect a non-spouse to inherit it, I suggest you revisit your strategy. Next slide, please. So very briefly here, we just wanted to include this slide here. There are, of course, many other types of trusts. There are so-called charitable remainder trusts that provide essentially a tax-efficient way to support your charities. There are irrevocable trusts, essentially where you permanently transfer your ownership of your property into the trust. There are ILETs, which is essentially the same thing, but for life insurance. There are, of course, special needs trust for disabled people, and relatively new ABLE accounts that serve a similar purpose, but they're designed for those who do not necessarily want to deal with the complexities of creating a trust. So if you have any interest in discussing any of these, please reach out to us after this webinar, and we'll be happy to cover that for you. Next.
So one strategy for reducing the size of your taxable estate is to make gifts during your lifetime. And the current annual gift tax exclusion is $15,000 per person per year. So, at the end of the year in 2020, you could give $15,000 to children, grandchildren, and then you could turn around on January 1 of 2021 and do the same, and effectively have moved, $30,000 per person out of your estate at that time. You can also give $15,000, above $15,000 in certain circumstances that involve medical bills and tuition bills, as long as those amounts are paid directly to the institution. It's very important. So if you decide to pay the tuition of a grandchild, you want to make the check out not to the child, but make it out to the actual college or university and pay that tuition bill. Same for medical bills. And then, of course, charitable contributions to exempt organizations are excluded from gifting of greater than $50,000. A gift tax return, which is called a Form 709, is required if you make gifts in excess of the $15,000 per person. And this does not apply to gifts between spouses, U.S. citizen spouses. Those are excluded. How could you avoid having to file a 709? You can straddle over the year, as I just mentioned, between 2020 and 2021. You can also consider making a loan, as long as it's a legal loan that carries an interest component to it, and is an official written document, and then forgive that loan over the future years. So there are ways to structure if you do want to be, say, giving real estate to someone, and obviously it has a value of greater than $15,000. That's something you should consult with financial planners and attorneys to help you if you're in that circumstance. 529 plans, I think many of you are aware that you can fund college for children, grandchildren. It's a great way for grandparents to leave an educational legacy to their grandchildren. You can fund the $15,000 annual limit, and you can actually elect to fund $75,000 under the current rules by filing a gift tax return and making an election that you're essentially funding that in advance and spreading it over 5 years worth of contributions. And the contributions and earnings in a 529 educational plan are withdrawn federal and possibly state income tax free as long as it is used for qualified education expenses. Owners of 529 accounts, the value is generally not included in your estate. It can be called back if you do this 5-year election, but in general, it's not included in your estate. And upon your death, the account is owned by a separate owner that you name at the time that you open the account. Okay, about estate tax returns. Not all estates require an estate tax return. If you do have to file one, you file it on Form 706. In 2020, for those dying, 706 is filed when you have a gross estate plus taxable gifts during their lifetime valued at more than $11.58 million. However, there are circumstances where you're going to want to file the 706 even though the value of your estate is less than 11.58. This is very important. Put a star and exclamation point next to this line item because if you're married and you die, you want to be able to leave your unused exemption to your surviving spouse. And in order to do that, you have to file the Form 706 to transfer that DSUE exemption to your surviving spouse. Generally, you must file the Form 706 to report the estate or generation skipping tax within 9 months after the date of the decedent's death. And you can also receive an extension of time if you're unable to file by the due date. So let's talk about what the different rules are for federal and DC, Maryland, and Virginia. Before the Tax Cuts and Jobs Act of 2017, you'll see for federal taxes, it used to be 5.49 was the exemption. And you would pay a tax at 40% rate to the extent that maximum of 40% to the extent that the estate exceeded that value. After the Tax Cuts and Jobs Act and what is in current law, that value is 11.58, as I just mentioned in the previous slide. Now, when Congress sets laws, it's supposed to be revenue neutral, and so consequently, the Tax Cuts and Jobs Act of 2017, in order to make it revenue neutral, they had to have a sunset provision such that that change in that law expires at the end of 2025. So in 2026, the estate tax will revert to the pre-2018 level of 5 million, and it should say inflation adjusted. From what I've read, that means it could be actually 6 or 7 million, depending on inflation, estimates at that time. In terms of DC, in 2017, the state tax was exemption was 2 million. DC increased it to 5.7 million, and that's what it is at now. And the mayor signed in August 2020 a bill that would reduce, effective 2021, January 1st of 2021, reduce it to a $4 million exemption. And the DC state tax rate is 16% for amounts exceeding that exemption. In Maryland, and we were at 3 million. Now we're at 5 million, and that does not sunset. That stays current for now. Maryland also has an inheritance tax. It's a 10% tax, and it depends on who the asset is transferred to. So something just to keep in mind of that. Virginia has no estate tax. It's one of the advantages of living in Northern Virginia. And we've asterisked there all of the states that do not impose a state estate tax at this time. We had many questions that came through as people were registering for this event about how the estate tax might change under a Biden administration. And Vice President Biden has he has produced a tax plan that you can read on the internet, but we'll summarize it for you here. Essentially, he is proposing a $5 million estate exemption. So essentially going back to the pre-2018 estate exemption amount. And secondly, he is proposing to eliminate the step up in basis for inherited assets. And what would happen is an heir, in the example of the real estate that I gave earlier, rather than receiving the value of the real estate at the stepped up value at the date of death, they would receive what's called a carryover basis. So the tax basis that the decedent had at the time of their death would carry over to the heir. So essentially it would mean that there's no more skipping, if you will, of from a low tax basis up to fair market value. That would be gone, and eventually somebody would end up paying tax on the value of that appreciated asset. Okay,
All
so
right.
now we're ready for the Ask the Experts panel. Joe, can you introduce our experts?
Sure, absolutely. So Gail Halpern and Thomas Burton are our experts today. And Gail is a senior advisor and consultant who specializes in trust, estate, and gift planning, and trust and estate administration and tax return preparation services. She also helps family trustees and executors maneuver through complicated trust and estate administration issues, and she is a CPA. Tom Burton is a senior tax manager at CBM. He has expertise in estate planning and has extensive tax management experience for partnerships and S corporations. He also delivers services in the areas of fiduciary and individual taxation. Tom is a CPA and an MBA.
All right, so we have very many questions here, and I'll tell you, these questions, they'll actually clarify on what we've been discussing today. So I'll start with the first question. Do payable on death bank accounts replace a trust as far as avoiding probate? What are important differences as compared to a trust to consider before relying on POD/TOD, transfer on death, to transfer assets to spouse or children if both spouses were to pass? So Gail, perhaps you would want to address this question.
Sure. So first of all, good morning, everybody. Thank you for having me. A payable on death account, while it protects the asset from probate, that's not everything that a trust would accomplish, on the other hand. So a trust is not just about avoiding probate. A trust allows for ease of access to the funds by the co-trustee, and it also allows for ease of trust administration by the successor trustee when the person who set up the trust is no longer able to manage the trust, if he's no longer living, or if he's out of a country just very far away and is not able to access the funds, and he needs somebody to access those funds for him. I wanted to mention something that Alex mentioned during the presentation, which is very important, and that is that a trust allows you to control your assets from your grave. So the trust document is going to talk about how assets will be distributed, who's going to get it, when, at what point. Perhaps you've got children that you feel should not get all the assets at one time, and you want them to kind of get used to inheriting assets. So you want to put those assets in a trust for them. And they would then get income over lifetime. There'd be a friendly trustee who knows the family, as Alex was mentioning, and would allow to give corpus distributions, additional principal distributions. But this is a way to make sure that not all the money that your child inherits gets spent all in one day. Another advantage of Well, let's just say another issue with having payable on death accounts, and just to clarify, maybe we need to explain what that is. Let's say you've got a bank account at, just use an example, Capital One Bank, and you've got $20,000 in there. You can go to the bank and say, I want to have a designated beneficiary on this account, and I want my son Charlie to get this money when I'm no longer living. So when you die, all Charlie needs to do, assuming he's of age and majority, is take your death certificate and his ID to the bank and say, I am inheriting this account. I was the designated payable on death owner. And then, of course, the bank has to process it. But within a few days, usually, the beneficiary will get the money. When there's an account that has a payable on death designation, it bypasses your estate or your revocable living trust. It doesn't get joined in with all the other assets. So if in your estates and your assets, you've decided to have a bunch of payable on death accounts and make designated beneficiaries, you need to be aware of certain pitfalls. For example, if you have an asset in your estate or your revocable living trust, let's say your house, and then when you pass away, your house is going to require a lot of work for the executor/trustee to fix the house up in order to sell it. If the estate or the revocable living trust does not have funds to draw upon, how is the house going to get fixed up for sale? So that's one thing to keep in mind. Another pitfall to keep in mind is, let me best to explain it by giving an example. Let's say you own two accounts, and each account had $50,000 in it, and you have two children. And you decide, okay, I'm going to designate one account to one child and the other account to the other child. Over time, you don't keep track, you forget, which is easy to do, and you don't use up the accounts equally, and you end up depleting one account for whatever reason. You've now really disinherited that child because all you had were those two assets, and the asset going to child number one has been used up. So that is also something to keep in mind, and you really need to consult an appropriate advisor if you have these type of questions. Alex, did I answer all the points on that question?
Absolutely.
Okay.
It was a very detailed answer. Thank you, Gail.
All right. It was a detailed question.
Right. Here's another one. Would you please go over the best way to secure your assets if you have a young child as your main beneficiary? Tom, would you like to address this question?
Sure. Good morning, everybody. Yeah, giving title to a child is a problem because they can't themselves, sign documents legally. The best way would be set up some kind of trust for the child, and or have the assets put into a trust for the child that can be looked after and managed until they reach a certain age. Could be the 18, could be 25, could be 35. Some could be, you could earmark certain ones, like this money should be spent for education, etc. I mean, Gail's example of the paid on death accounts, of course, is another way. And is that good? Anything else anyone think of? Or
Gail, do you have any additional thoughts on that?
No, I think Tom answered the question for us. Thank you.
All right. So we do have many more. How's your state of residence determined upon death? Is it based on driver's license, state where will is filed, if one exists? Question mark. Gail, would you like to address this one?
Sure. So there are numerous factors that contribute to determining where one's what's called domicile for estate, estate tax purposes are at the time of their death. And as the question mentioned, there's the driver's license, there's the voter registration card, There's also one's physical presence and time spent in that state. There's the residences that the person might have owned during his lifetime. What state are they located in? Where did the family, the spouse and the children primarily reside? Where was the person employed? Where were the person's country clubs and other social clubs, place of worship? What state were those in? So while one's will actually does declare his where he is domiciled at the time that he drafted the will, there are other considerations that are looked into at the time a person dies. And then in terms of, someone had asked filing a will. So the will is not filed until the person passes away. It is filed with the jurisdiction where his estate is deemed to be domiciled. Alex?
Thank you, Gail. I believe that answers that. Here's actually a question from the chat box. I will read it again without mentioning the person's name. Can you go over how to set up the trust for a minor child? Is the designated estate executor the point person for them, or what do you do? Tom, I believe that was in response to your response. So would you like to briefly address this question?
Well, I mean, as we always say, we're accountants. You should, consult an attorney. I mean, why? If this is going to be a trust that's set up that you're not going to be able to look after because you've passed away, then it can be the person who is going to be the executive of your estate, but it doesn't have to be. It could be a trusted family member, even a neighbor or your lawyer or somebody else who, you think can look after the child's affairs. But to set up a trust, you would need to have an attorney help you draft it.
Understood. Here's another question. I do not believe it's necessarily related to this. Should we appoint more than one trustee so that someone else is looking over their shoulder to avoid abuse of power? Gail, what do you think about this question?
Good question. So there are actually circumstances where you have to appoint more than one trustee. And let me explain. If let's say you have a married couple and you've got a trust that is going to receive the assets for the benefit of the spouse, certain trusts designed in such a way that they will not be included in the surviving spouse's will upon, let's call it her, let's say the surviving spouse is her, upon her death. Those are, you might have heard the term, those are often referred to as a bypass trust or a credit shelter trust. So in those kinds of trusts where the surviving spouse, these are the assets where she is going to, let's say, use for the balance of her lifetime, she will be given certain powers to make certain type of distributions to herself. But there are some distributions which an independent trustee will need to make. So very often when you go to your estate planning attorney, he or she will tell you, okay, you want your spouse to be a trustee of that credit shelter trust, survivors trust. That's fine, but you need to have somebody else appointed in addition. So that answers the question regarding with spouses. But then let's say you've got, a non-spouse trust set up in your estate plan. First of all, you always want to have successor trustees because something could happen that the person you appoint might not be living or might not be well enough or for whatever reasons cannot accept the responsibility. So you do want to have alternates appointed. And then specifically to the point of the question is to having one, to avoid abuse of power, et cetera. If you suspect that there might be abuse of power, et cetera, do not even appoint that person to be even a co-trustee. Because like Alex was saying, and like I mentioned as well, you're controlling this from your grave, but what you're controlling is what you set up during your lifetime. So if you have any doubts whatsoever about a person, then that person really is not a good option. And it's a very good question, because this will often, come up the case with, let's say, within the family, with the children, et cetera. Now, having said that, though, it's advisable, especially if you've got, younger trustees, your children, for example, to, yes, appoint more than one of them. Don't go overboard, because then it becomes an administrative hassle. If you have 4 trustees and everyone has to agree to the decision, then it takes a very long time to get things accomplished. But having 2 trustees is very reasonable. And depending on the size and the makeup of your estate, a trust could be very cumbersome and time-consuming to handle. And sometimes it's just not fair to burden one child, even though they can get compensation for it. It's just not fair to burden that one child with managing all of those assets, and 2 people would be advisable in such a case.
Thank you. Thank you, Gail. So we'll take a few more questions. This one is from the participants that were submitted prior to this webinar. I have an old will from a retired attorney. Do I need to redo the entire will? How do I find a new attorney? Tom, what are your thoughts on this question?
I guess the main part of that is that it's an old will. The fact you have an old attorney, it really probably doesn't matter. An older attorney is a more experienced attorney. You should have your wills and trust and other documents reviewed, every so often. You could say maybe every 10 years, or if you've heard of a major law change. The other reason would be that you moved. So you just moved across the river from Bethesda to Tysons Corner, Virginia. Well, now you moved 10 miles, but you're now subject to Virginia law and not Maryland law, and that would be a good time to review your documents also.
Right, and one thing I will add, if any of you are interested, we work with different attorneys, many estate planning attorneys. We've been working with them for decades at this point. So if any of you need referrals, we would be happy to provide those referrals to you. Here's a next question. Do you advise on tax?
Alex, let's make this the last question, because yeah.
Sounds good. Okay, the last question then. Do you advise on tax implications of alternative estate scenarios, including major gifts? Gail, what is your response to that?
Good question. Thank you, Alex. Yes, we do. We provide estate planning services. We are not attorneys, as we've all mentioned several times, and we cannot draft a will or a trust, but we can advise you on different scenarios, including estate tax and estate planning, strategic gift planning and gift giving, and income tax considerations. Alex?
Thank you. Thank you, Gail.
Thank you. I'm actually going to, I just want to be mindful of all the participants' time. So we will be sending out copies of the slides along with the love letter, as we mentioned before. We are holding upcoming events next week. Alex and I are presenting along with a guest speaker about retirement and life care planning, how to build a path to a peaceful future. We have outsourced accounting success for your not-for-profit association, creating financial harmony, living together, engaged and newlyweds, and a market update on November 19th. We have a resource center, COVID-19 resource center on our website. So feel free to visit our resource center. And we do appreciate you for participating. If we were unable to answer your questions, you can email us. You can email myself or Alex. We also might refer you over to Gail and Tom. I'm not sure if we had their email on a previous slide. But we're here to help answer. We can't really provide specific advice, but we can certainly provide general advice. And we thank all of you for attending today. And we look forward to providing future educational seminars to you. So be well. Have a wonderful day.
Thank you, everyone. Thank you.
Bye-bye.
Bye-bye.
Bye-bye.